Well, welcome to the American Enterprise Institute. And thank you for joining us today for AEI's first annual Laurence Silberman Lecture on Law and National Security. Judge Laurence Silberman was a great American judge and statesman. Indeed, he was a truly singular figure in modern American government. From 1985 to 2022, he served as a judge on the U.S. Court of Appeals for the D.C. Circuit, writing landmark opinions in cases such as the constitutional challenge to the independent counsel statute. Before that, he served in the Nixon and Ford administrations as Undersecretary of Labor and Deputy Attorney General. But in the time between his service in those administrations and his later appointment to the bench, he was appointed by President Ford in 1975 to be the United States Ambassador to Yugoslavia. As his protege Paul Clement, who's with us tonight, observed in interviewing Judge Silberman for an oral history, a move from the Justice Department to ambassador to Yugoslavia is, quote, not the most obvious lateral move, but it exemplified Ambassador Silberman's lifelong interest in foreign policy, and will be just the first part of his service on matters of national security. From 1996 to 2003, Judge Silberman heard appeals on the U.S. Foreign Intelligence Surveillance Court of Review, exemplifying his dedication to both the rule of law and national security. In 2004, President George W. Bush appointed him to co-chair the Iraq Intelligence Commission, and in 2008, President Bush awarded him the Presidential Medal of Freedom. For all these reasons and many more, AEI is honored by Judge Silberman's connection to our own institution. Between the Ford and Reagan administrations, he was a senior fellow here at AEI, writing on foreign policy, regulatory reform, and the rule of law alongside Antonin Scalia, Robert Bork, Irving Kristol, Walter Burns, and other greats. Many years later, in what proved sadly to be the last years of his life, Judge Silberman returned enthusiastically and generously to participate in AEI's conferences and conversations. Last year, his family, friends, and admirers established AEI's Laurence Silberman Chair in Constitutional Governance, which I am honored to hold. And AEI established today's event, the annual lecture that bears his name and embodies his legacy, the Laurence Silberman Lecture on Law and National Security. And for this first annual Silberman Lecture, we are grateful to be joined today by Judge Silberman's family, including Mrs. Patricia Silberman. And to inaugurate the Silberman Lecture, we're truly honored and grateful to be joined by Attorney General William Barr, a man whose own life and work mirrors Judge Silberman's values and public service. Bill Barr served as the 77th and 85th United States Attorney General, first under President George H.W. Bush from 1991 to 1993, and then under President Donald Trump from 2019 to 2020. Before his first appointment as Attorney General, he served as Deputy Attorney General, and he led the Justice Department's Office of Legal Counsel. As Attorney General, he argued a case before the Supreme Court. And then after his first period in public service, he was General Counsel and Executive Vice President of GTE and Verizon. There, too, he twice appeared before the Supreme Court, arguing major cases on telecommunications and administrative law. Throughout his career, Attorney General Barr has spoken eloquently and often colorfully on the Constitution, the rule of law, and the values and traditions that sustain them. But like Judge Silberman, he's also dedicated much of his work and career to American national security. Indeed, his study of national security preceded his career in the law. In his 2022 memoir, One Damn Thing After Another, he recounts meeting with his high school guidance counselor. I want a career in intelligence, he told the counselor. My strategy is to make myself an attractive candidate by becoming an expert on China. But, Barr recounts, it was a short meeting. A short meeting, but a lifelong vocation. He would indeed attend Columbia, study China, and secure internships at the CIA. In his memoir, he writes that, quote, my summers at the agency were some of the best times in my life. But, he added, my studies had kindled a deep interest in the law as well, especially constitutional law. So he went to George Washington Law School, began a career in law, and soon in public service. Yet he never lost sight of America's powers and responsibilities on the world stage. As Attorney General, he would return to questions of foreign policy in key speeches on China's challenges at the Justice Department's China Initiative Conference and a speech on China policy at the Gerald Ford Presidential Museum. Since 2021, he's continued to return to these questions. In his memoir, In his work at the firms he co-founded, Torridon Law and the Torridon Group, and at the Hudson Institute, where he is a distinguished fellow. For all of these reasons and more, there could be no one better to give the first annual Laurence Silberman Lecture on Law and National Security. We're genuinely honored and grateful to welcome him today. So please join me in welcoming Attorney General William Barr.
Thank you. Good evening. It's good to see Trish Silberman and the Silberman family here. And I'd like to commend Robert Doar and AEI for establishing this legacy project and thank my friend Adam White for his leadership on it. It's a big honor for me and privilege for me to have been asked to deliver the first or the inaugural lecture on law and national security in honor of Larry Silberman. I was honored to know Larry. We met during the transition of the Reagan administration when we were introduced by our mutual friend, Mike Uhlman. And before long, as will surprise no one here, I was the beneficiary of his career advice, his warm friendship, and his general kibitzing on many aspects of my life. To my mind, Larry was a great lawyer and a great jurist, not just because of his powerful intellect and his broad erudition, but precisely because he was a man of practical affairs with broad experience in government, diplomacy, and business. He was highly principled, but he was also a practical statesman who understood that law and judging are not abstract academic exercises. They're part of the business of governing the republic. Today, our jurisprudence sometimes feels like the fussy scholasticism of the late Middle Ages. I emphasize the word late. Too cute by half and unfit to grapple with practical reality, especially in the realm of national security. We need more jurists like Larry. When I started in CIA, and incidentally, I stayed on at CIA and only went to law school at night, I used to say that I learned the law at night and violated it by day. But as I recall, when I joined in '71, there were roughly 10 lawyers, or at least people serving as lawyers, in the building. My responsibilities required that I review many historical programs that had been directed against hostile foreign persons, groups, and countries during the Cold War. I had to dig around for the legal analysis that had been done in the 40s and 50s to support these programs. And these were usually found on yellowing, flimsy, creased carbon paper tucked away. And typically the analysis took up only about half a page, the size of a footnote today. In other words, I'd say the analysis was very pithy. And it was also right. As you might expect, the president's inherent authority as the commander-in-chief and the chief executive of the nation under Article 2 of the Constitution figured very prominently in this analysis, as it should have. The men who guided us through the Cold War had an intuitive understanding of the import of Article 2 and the governance structure contemplated by the Constitution to provide for the common defense against hostile foreign adversaries in a dangerous world. Unfortunately, in the past 50 years, there's clearly been a vast overjudicialization in the national security sphere. Today, there are not 10 lawyers at the CIA, but hundreds. The same exponential growth has occurred throughout our national security establishment. And at the same time, we've had an explosion in textbooks and law journals and law school programs devoted to so-called national security law. Judges have been increasingly willing to review and second-guess executive branch defense and foreign policy decisions, even where the action is directed against non-U.S. persons and where the rights of individual U.S. citizens are not implicated. And those are the kinds of cases I'm talking about tonight. Not cases where the government imposes domestic security measures that trench upon the civil liberties of American citizens. Not cases where the government targets and penalizes a particular American citizen in the name of national security, but cases where the United States uses its defense powers, its military, intelligence, and other kinds of sanctions against foreign persons who have no connection with the United States. And it does this so as to neutralize a national security threat those persons are considered to pose. My general impression is that there is a greater readiness of the courts to insert themselves into defense and foreign policy matters that has gained traction started to gain traction in the late 1960s, in tandem with three developments. The reaction against the Vietnam War, when liberal thinking became more dogmatically pacifistic and more disposed to view the United States as an oppressive imperialist power. The exponential expansion of personal and procedural rights as checks on government activity within the domestic arena, particularly in the criminal justice system, and the growing hubristic tendency of the courts to impose the judicial model on virtually every kind of decision-making in our society. The notion is that the propriety of just about any decision can be judged by determining whether it satisfies some tidy evidentiary standard, and that such a judgment must be made by a neutral arbiter based on an adversarial process. To my mind, the consequences of this overjudicialization has not been good. We have a military that can't detain prisoners of war because of the massive burden of having to litigate waves of habeas petitions throughout the federal courts. And we present to the world the shameful spectacle of a country that has had in its custody for over 22 years the individuals responsible for the 9/11 attacks, the most heinous and bloody attack on our country that we've ever experienced, and yet a country that has tied itself in such legal knots that it is unable to bring these people to justice. If the national security jurisprudence we have today existed in 1940, I'm afraid I'd be giving this lecture in German. When I look at the judicial decisions over the past 50 years, I see a marked tendency for judges to consult the constraints and premises constitutionally mandated in our domestic law enforcement realm and transpose and apply these, sometimes subtly, in the very different context of military and national security actions directed against foreign threats. Courts seem to approach virtually every case with the same mindset, that their role is to protect the individual against the government abuse of its powers by reviewing the action as a neutral arbiter and determining for itself whether the government's actions were reasonable and justified. Now, of course, courts pay lip service to national security considerations. The usual weasel word is deference. Where national security considerations are present, they say they are factors that they have to take account of and say that they owe some deference to presidential decisions. I cringe when I hear this because the term deference connotes that the court sees itself as ultimately retaining decision-making authority and that it is only giving weight to the judgment of the executive. But this is not the kind of deference owed. The point is that when it comes to wielding the defense powers against foreign adversaries, the ultimate substantive decision rests with the president. His judgment is entitled to more than weight. It is determinative, and the courts have no authority to substitute their judgments for that of the president. To my mind, the most grotesque usurpation of executive power in our history was played out during the administration of George W. Bush, when the American judiciary went on a spree and in a series of cases set themselves up as the arbiter of decisions that lie at the very core of the president's discretion as commander-in-chief. And foremost among these is the Supreme Court's 2008 decision in Boumediene. In Boumediene, the court overruled hundreds of years of American and earlier British law and practice, which had always considered decisions as to whether to detain foreign combatants to be purely military judgments, which civilian judges had no power to review. Boumediene dealt with the al-Qaeda leaders and combatants captured while operating in Afghanistan and Pakistan and held in Guantanamo. For the first time, the court ruled that foreign persons who had no connection with the United States other than being confronted by our military in the theater of battle enjoyed a constitutional privilege of habeas corpus to obtain judicial review of whether the military had a sufficient evidentiary basis to hold them. This effectively conferred on enemy prisoners of war due process rights akin to those a criminal suspect has under our domestic criminal justice system. This was a radical departure from both the purpose and the history of the writ. Both conceptually and as a matter of consistent practice, the privilege of the writ was only available to the king's subjects as a means of ensuring that the liberty rights of the subject were not infringed by arbitrary arrest and imprisonment. Over time, the privilege was extended not just to citizens, but also to foreign persons whose conduct put them under the protection of the king or established some degree of allegiance, what has been referred to as being local subjects. But one thing is historically clear. Over many hundreds of years, in neither the United States nor England has the writ been available to allow foreign combatants to challenge their detention as prisoners of war. Boumediene opened the floodgates for prisoners captured during the global war on terrorism, allowing for the litigation of hundreds of habeas cases, judicial scrutiny of the quality and persuasiveness of the government's basis for holding the captives, and court-ordered release of many prisoners of war. This ruling has degraded the capabilities of the U.S. military. Since the decision came down, the ability of U.S. forces to take and hold prisoners of war has been effectively paralyzed by the idea that once detained, enemy combatants have a constitutional right to litigate in federal court the adequacy of the military's basis for detaining them. And the court has not deigned to give guidance on the kind of due process rights they are supposed to have and what they will require, what the courts will require in the way of collecting and disclosing sufficient evidence to justify their detention. We don't know, even to this day, what the standard is. Boumediene is a prime example of the tendency of courts to take constraints that govern our domestic criminal justice process and carry them over and superimpose them on the nation's activities when engaged in armed conflicts with foreign enemies. Throughout the decision, the Boumediene court repeatedly expounds on how important the writ of habeas corpus has been in protecting the people's liberty against the threat of arbitrary, tyrannous government. It cites countless examples taken from the criminal justice cases in both England and the US. It goes on to say that the security of the country doesn't only require the ability to resist foreign enemies, but, quote, security subsists too in fidelity to freedom's first principle, Chief among are freedom from arbitrary and unlawful restraint and the personal liberty that is secured by adherence to the separation of powers. Here, by separation of power, there was no dispute with Congress. Congress supported the executive in this. By separation of powers here, they're talking about the role of the courts as supervisor of executive action. But of course, this dodges the question, whose personal liberty is to be protected? The right of every human being, the rights and freedoms of every human being on earth, including those who are fighting against the United States? No. In England, it was the right of the king's subjects, the right of Englishmen. And in the US, the Constitution is concerned with the rights of the people. Despite the fact that during the past 400 years, Britain and the United States have held millions of prisoners of war detained inside our respective countries, 425,000 during World War II, there is not a single case allowing a foreign POW to use the writ of habeas corpus to obtain release from detention. And by the way, of the 425,000 here in the United States during World War II, hundreds were natural-born US citizens, Germans and Italians, who fought for the Axis. Did they get access to courts to claim that they were citizens and shouldn't be held? And hundreds and thousands more were troops that were caught, that were labor battalions that had been dragooned in from the Soviet military, such as Mongolians. And they said, we're not part of the Nazis. Did they get into court to get sprung free? No. Now, there are three cases typically cited to show that foreign prisoners of war enjoyed the privilege of habeas corpus, but they actually show the opposite. Three cases over 400 or 500 year history. In 1693, an Englishman was captured by the British while captaining a French ship and held as a prisoner of war. And on a writ of habeas corpus, the court granted him bail, but entertained the claim because they found that he was, in fact, a subject of the king. In 1759, a Swedish subject claimed he had been forced into service on a French privateer before the privateer was captured by the English. The court entertained his habeas petition only to the extent of establishing that he was being held as a prisoner of war, and held that because of that status, the court could not give any redress. And finally, in 1779, 3 Spanish sailors captured by the British and held as POWs sought habeas relief on the grounds that they had ceased being enemy because they volunteered to serve on an English merchant ship. The court entertained the petition only so far as to determine their identity and status, and ruled because they were being held as prisoners of war, the court could give no redress. This is the slender reed upon which the court ruled that foreign prisoners of war have the right to litigate in federal courts whether the U.S. has sufficient evidence to detain them. Now, the court's approach makes no sense as a matter of constitutional theory. The rationale for judicial supervision of the government in the domestic and law enforcement sphere simply do not exist when the government is taking military measures against foreign persons. Let's consider the basics. There are 2 reasons why society establishes government. First, to preserve internal peace, and second, to protect the community from external attack. This dichotomy is obviously played out in our own Constitution. To ensure domestic tranquility, the Constitution confers on the federal government its domestic law enforcement powers. To provide for the common defense, the Constitution confers on the federal government its national security or defense powers. These are 2 distinct realms of activity involving very different considerations. The book of Exodus relates a striking story about Moses when he first left the Pharaoh's household where he had been raised and started to take on his role as leader of the Hebrew people. He first encounters 2 Hebrews fighting with each other. He breaks up the fight, admonishes them, and sends each on their way. He then encounters an Egyptian beating up a Hebrew. He slaughters the Egyptian and secretly buries him. Commentators tell us that this story was meant to show that Moses was taking on the core attributes of communal leadership, keeping order within the community and defending the community from outside aggression. But what is striking about the story is the very different approach Moses uses in dealing with each of these threats. As this story reflects, there's a distinction between the role the government plays domestically when it's asserting discipline against members of the body politic and the role it plays when it is defending the body politic from outside aggression. When the government acts in its law enforcement capacity, it's a disciplinary function. It's ensuring tranquility by punishing the errant member of society by transgressing the internal rules. But as the framers well understood and frequently discussed, this internal policing role raised a problem, the problem of free government. As Madison explains in Federalist 51, the ultimate goal is to protect the liberty of those who make up our community. But if the government is strong enough to keep order by disciplining its own members, it can also abuse its power and therefore itself become the oppressor of the people's liberty. Thus, our Constitution makes a fundamental decision to sacrifice efficiency in the domestic law enforcement realm by guaranteeing that no punishment can be meted out in the absence of virtual certainty of individual guilt. Both the original Constitution and the Bill of Rights contain a number of specific constraints on the executive's law enforcement powers, many of which expressly provide for a judicial role as a neutral arbiter or check on executive power. In the realm of in this realm, the executive's subjective judgments are irrelevant. It must gather and present objective evidence of guilt satisfying specific standards at each stage of the criminal proceeding. The idea is that in this realm, we have to avoid mistakes that cause collateral damage. The punishment of someone, to punish someone, we have to show that they deserve it. The underlying premise is that it is better for society to suffer the cost of the guilty going free than face the systemic threat to liberty of unchecked police power. But the critical point is that the Constitution takes this approach because the goal is to protect the liberty of the American people, whose liberty would be threatened by overweening government. But these considerations are inapplicable when the government is defending the country from aggressors from outside. On the contrary, when facing external attack, protecting American people's liberty requires that we maximize the government's power to act against foreign enemies. The Constitution is concerned with one thing: preserving the freedom of our political community by destroying the external threat. And here the Constitution is not concerned with handicapping the government to preserve other values. The Constitution does not confer rights on foreign enemies. Rather, the Constitution is designed to maximize the government's efficiency to achieve victory, even at the cost of collateral damage that would be unacceptable in the domestic realm. Rather than dilute the government's power, the Constitution seeks to unify and strengthen the power of the government when facing a foreign adversary. It does this by vesting responsibility for making decisions in the political branches, which are the branches that are accountable to the people for protecting society. When the country is defending itself against the external aggressor, courts have no role to play when it comes to the interaction of our military and our foreign adversary. The judicial branch does not sit as a neutral arbiter as between our society and our foreign enemies, or as a second guesser of military decisions. The idea that the judiciary acts as a neutral check on the political branches to protect foreign enemies from government overreach is insane. Now, not only does our Constitution contemplate judicial supervision, not contemplate judicial supervision against supervision of military decisions against our foreign adversaries, but the very nature of the military decision-making precludes judicial administration and supervision. There are simply no judicially manageable standards to either govern or to evaluate military operational judgments. We have lost sight of the fact that many critical decisions in life are not amenable to the judicial model. They cannot be reduced to evidentiary standards and specific quantums of evidence in an adversarial process. They require what we used to call prudential judgment. For most of our history, military decision-making was seen as the classic example of the kind of decision-making that was political, not juridical or legal in nature. Even the most cursory consideration shows that the nature of military decision-making is profoundly different than the kinds of decisions we make in the domestic law enforcement arena. Neither international law, nor the Constitution, nor any other domestic law purports to specify that there be a particular quantum of evidence that satisfies a particular standard as a predicate to either killing or capturing a suspected enemy. What would the standard be? Reasonable suspicion, probable cause, substantial evidence, preponderance of the evidence, or beyond a reasonable doubt? And what would the standard of review be? These decisions are not susceptible to being reduced to an evidentiary standard. They necessarily involve prudential judgments made on incomplete information that will always be incomplete, and necessarily involve weighing a wide range of competing risks and making predictions about the future. Indeed, the military decisions commonly involve what is called a precautionary principle, or at least a variant of the precautionary principle. This is the principle that where there is some uncertainty as to whether taking action is warranted, but the cost to your side of failing to act could be very serious, then it is best to take the action, because it is better to be mistaken and safe than mistaken and sorry. That's the precautionary principle. And a good example of it was portrayed, or it was, in fact, the raid into Pakistan to kill or capture Osama bin Laden that's dramatized in the movie Zero Dark 30. Some of the participants in that decision to launch the operation have said repeatedly that the evidence that Obama was there in the targeted house was no better than 50-50. In a key scene in the movie, and this is an excellent screenplay, but in a key scene in the movie, the senior CIA official tells the national security advisor, who kept on asking for more and more data, that he should stop worrying solely about the cost of being wrong and start considering the cost of failing to kill Osama when he has the opportunity. That's the precautionary principle. That's the kind of thinking that is constantly present in the military realm, but could never occur in dealing with criminal suspects. Another dramatic, though less successful example of the precautionary principle at work involved the Allies' desperate effort in the Italian campaign in 1944 to break through the Winter Line so that they could move up the Liri Valley to capture Rome. And overlooking the assault route was the huge mountainside monastery, Monte Cassino, one of the great treasures of Western civilization, dating from the 10th century and founded by St. Benedict himself. Now, the German general promised that to save the monastery, he would not let his troops enter or use it. The Americans didn't think the Germans were in the monastery and wanted to spare it. But the lead assault troops were to be the New Zealanders, and their commander argued that it had to be destroyed because if the Germans were in it, even if the chances weren't that high, but if the Germans were in it, his troops would be decimated, and thus the risk of failing to destroy it were just too high. Eisenhower reluctantly went along with this better safe than sorry reasoning. Unfortunately, the decision proved to be a mistake. The Germans were not using it, and the only people killed were the Italian civilians who were taking refuge there. And it ultimately, as a destroyed target, proved to be a much better defensive position for the Germans. The precautionary principle also comes into play in framing rules of engagement. Such rules involve a trade-off between the degree of certainty one will require before using force and the cost that might entail, both in reducing military effectiveness and American casualties. Generally, when a commander tightens the rules, he is sacrificing efficiency and risking American lives. Now, that's an appropriate balancing to undertake, but the key point is that the Constitution doesn't perform that balance. There is simply no law that would tell a judge or anyone precisely how that balance should be struck. It is a judgment call that is left to the political branches. The extension of due process concepts to military operations fundamentally changes the nature of war and is incompatible with the power to wage war itself. To the extent that decisions to detain persons as enemy combatants are based in part on the circumstances of the initial encounter on the battlefield, frontline troops will have to concern themselves with developing and preserving evidence as to each individual they capture, at the same time as they're trying to confront the enemy forces. They would be diverted from their primary mission, the rapid destruction of the enemy by all means at their disposal, to taking notes on the conduct of particular individuals in the field of battle. Further, under this habeas corpus regime, the military would have to take on the further burden of detailed investigation of detainees' factual claims once they are taken to the rear. Again, this would radically change the nature of the military enterprise and make the conduct of war, especially irregular warfare, vastly more cumbersome. For every platoon of combat soldiers, the United States would have to field 3 platoons of lawyers, investigators, and paralegals. This would divert resources from winning the war into demonstrating the individual fault of persons confronted on the field of battle. One of the absurdities of trying to impose the law enforcement model on detainees is that unlike domestic law enforcement, our military forces do not have access to evidence on the other side. In the domestic setting, the presumption of innocence and all the evidentiary rules we have make a modicum of sense because the government has the plenary authority to gather all relevant information through compulsory process and has nothing better to do. That's the job of law enforcement. But in war, and especially we don't have access to the information. We can't subpoena Al-Qaeda's records, and our military personnel have better things to do, like fight the war. This is particularly galling in the context of irregular warfare, where our adversaries are violating the rules of war, specifically by not differentiating themselves from civilians, not wearing uniforms that clearly mark them out as enemy combatants, but hiding among the civilian population. And the rule that we have to sort this out and build a case against each essentially allows them to use this device to the detriment of the American people and their safety. I think we all treasure the role that the independent judiciary plays in protecting our personal liberties. And it's vitally important that the courts remain ready, willing, and able to stand up against overreach by our government when it infringes on our rights. Unless they do, those rights mean nothing. But the rights that the judiciary is charged with protecting are the rights of those who are part of our political community. The Constitution was not written for the world at large. It was written to secure the rights of the people of this great union. I think we all have to stand up and defend the courts when they are performing that role and resisting government action that trenches on our liberties. But at the same time, the Supreme Court and our judiciary have themselves frequently been overweening and arrogated power to themselves that they do not have. In many ways, we have come through a half-century of judicial imperialism. And I hope we're through it, and I think we are. But by intruding into areas that it has no business in, and second-guessing decisions that are the responsibility of the political branches, the court has done a lot of damage. Damage to their own prestige and damage to our country. And the recent absurd opinion coming out of California denying the president's authority over the National Guard reminds us that there is no proposition that is too crazy, that you cannot find some federal judges somewhere to embrace it. It is good that this Supreme Court has adopted a more conservative approach, but in many areas it is still leaving in its wake a lot of destruction and legal chaos. It would be nice to see the court show a little more energy in straightening out some of the confusion it has contributed to over the years. Unfortunately, part of the court's conservatism involves some temporizing and avoidance in areas where there is pressing need to remedy past mistakes and clarify the law. And one of those areas is national security. The solemn duty of our government, the judiciary included, is to preserve and protect the freedoms of the American people. Sometimes our freedoms are threatened not by our own government, but by external enemies. And when that happens, we depend on our government mounting the most robust and vigorous defense it can muster. The notion embodied in Boumediene that in these circumstances, the courts have the power to restrict the government's decisions on how best to defeat the foreign threat is an abomination. Boumediene delenda est. Thank you.
Well, that was great, and you've given us a lot to think about. I have a few questions about some
Is
of
mine or yours?
yours is over there.
Okay.
I have a few questions about some of the issues you raised, and I think members of the audience may have a couple of questions. But before we get to that, I want to go back to the very, very beginning. I said in your memoir, you sketch out this great story of how you became interested in these things as a young man, as a boy even, and how you came to this worldview and it really shaped your vision of what your career would be. How did you come upon that so early in your life? How did you realize that China would be one of the great geopolitical issues for America going forward, so much so that you wanted to dedicate your career to public service beginning in intelligence?
Well, it sort of shows two things about my planning. One, I do believe in looking ahead and doing some planning. And I was always interested in intelligence. My father had been in OSS during World War II. And it was obvious that everyone was studying Russian that was in the field of foreign affairs, foreign policy, defense policy, and so forth. And I said, well, wait a minute. I mean, China is going to be a formidable threat. And just looking ahead, they're going to be the next big problem. And they have a lot of advantages over the long haul. And so I thought, I'll get into that field because it's open. So it was just, plain, ordinary planning, looking down the road. But also, plans last as long as first contact with reality, right? I go into CIA, and I end up becoming a lawyer and going to law school at night and sort of got off that road. So it was foresight, but it didn't do me very much good.
Maybe we'll get back to that in a little bit, but again, looking back at your career, so you become a lawyer, you wind up in the Justice Department, OLC, Deputy Attorney General. Those are not jobs that go to people who don't already have a pretty firm and well-thought view of our constitutional system. But what you described to us now, the responsibilities for the president and his chief, the heads of the agencies, It requires so many prudential judgments, so many things that you can't study in books. I'm curious, how is your sense of our constitutional system shaped by your time as Attorney General? Seeing these things from a vantage point that so few people in the American political system ever get to see.
Well, even before that, I mean, I've always loved history, and I read principally history and biography. and for most of my life, up until I was Attorney General, the main focus was American history and British history, and that tells you a lot. You learn a lot from that. But when I got into the department and started working with the great men and women at the Office of Legal Counsel, all the toughest problems come to them. All the toughest legal and constitutional problems come to that office. And so it was quick immersion and learning for me about these issues. And they were sometimes very urgent and weighty issues, such as, well, I had left OLC and was Deputy Attorney General when the President asked me whether he could move our 500,000 troops into Kuwait. And, that's sort of like, the out-of-body experience for the head of OLC or someone who's been in OLC. But it was basically learning from all the people in that office. 2 weeks after, I tell this story a lot, which is that 2 weeks after arriving in the office, I got a call from DOD, Deputy General Counsel, saying, Delta Force is staging out of Puerto Rico, is right off, they're airborne, they're approaching the Panamanian coastline, and they're going to snatch Pablo Escobar, who we believe is in this villa on the water, a guest of Noriega. The question is, does this violate posse comitatus? And I said, how far out? He said, they're like 15, 20 minutes out. Could you give us a verbal opinion with written to follow? And I said, well, clearly it does not violate posse comitatus. There's no issue there. And then I hung up and I called John McGinnis, who was the career deputy at that point. I said, John, what's the posse comitatus? You learn practicality as the head of OLC. I knew I was not going to stop that mission, but I turned out to be right. I actually had a sense that it was right because I knew that the reason we probably don't want the military carrying out law enforcement is we don't want them coming and clashing with the American people, and that's not a consideration that exists outside the United States. That ran through my mind, and that turned out to be the winning argument. But
lucky guess.
We won in the Supreme Court.
So you serve as Attorney General, you're going on to a very interesting career in private practice. You wind up coming back for a second run as Attorney General. Glutton for punishment, or
I don't
what?
know. Maybe it was a run. Maybe it was running the gauntlet.
Yeah.
But yeah.
Well, what brought you back for that second stint? Obviously the president's appointment brought you back, but what was it that stirred you to return to government after this time away to do this job once more?
I thought it was obvious to me that Sessions was going to be replaced after the midterm, and a lot of people were bandying about possibilities, and I was pushing various people I knew that I thought would be good. I had no desire to do it at all, but over time, the president kept on asking to speak to me. I think people on the Hill and others were telling him that I'd be a good choice. And at the end of the day, I felt that there was essentially a coup orchestrated against the president, and that he was not being allowed to govern. He was the duly elected president. He should have a chance to run an administration. And he was being smothered with all this nonsense about Russiagate, and the usual, leaders of the bar in Washington D.C. were on the sidelines. No one, and there weren't that many people willing to go to his aid. And I eventually persuaded myself that I wouldn't talk to him unless I would say yes. And I eventually decided, okay, if he asked me, I would say yes. So I went and talked to him. Now, this was in close consultation with my family. I had my daughters, two of them were in the department, two son-in-laws were in the department. We talked it over. I knew it would affect them. And they were generally of the view, someone has to do this. This is out of control. Someone has to come in. So I thought, that I might do it. My wife held out for a while, but then after she watched the Kavanaugh hearings, she came walking in and she said, if you think you have to do it, do it. Someone has to stop these bastards. So that was the final vote.
That wasn't. Just occurs to me that one of Judge Silberman's most famous opinions, I guess surely his most famous opinion, was on the old independent counsel statute. And this is one of those sort of timeless questions in modern American government. How do we handle this constitutional question of a president with such enormous power atop the executive branch? What happens when either the president himself or more often people within an administration are accused of wrongdoing? What's the right way constitutionally and politically to handle that? And Judge Silberman had his famous D.C. Circuit opinion. Justice Scalia had his dissent in Morrison v. Olson. But Chief Justice Rehnquist, he was no constitutional slouch. He saw it very differently in Morrison v. Olson. Just in very general terms, how do we handle this question in modern constitutional government of how to go about investigating wrongdoing within administration itself?
So I think by their fruits you shall know them. And one thing I can guarantee you is that the independent counsel statute is not the way to go. Unsupervised prosecutors are tyrants, have always proven to be bad for the country. It took the Democrats a while to figure that out, but then everyone agreed, enough of this. These are doomsday weapons. And so that's not the way to do it. We're going to see, I think the right answer is that people have to pay attention if our electorate has the capacity to make sober decisions about who's president and also the Senate as to who's Attorney General. Because I think that the Attorney General has the responsibility as Attorney General to administer the criminal justice system. And if people in the administration are violating the law, he has to be ready, he or she has to be ready to deal with that and pursue it. We're going to see, with the experience with this administration, how a system works where the president has immunity, which he should have immunity, and it puts a lot of stock in loyalty of his cabinet officials, which he means personal loyalty. And we'll see how this system works. And eventually, we may come to the resolution that I think is important, which is elect good people as president and make sure that the Attorney General is someone who is loyal to the president's program, supports the administration, but at the end of the day understands that their key job is to apply the law without favor.
You mentioned the president's immunity, and of course, that's the product or it was recognized in a recent Supreme Court decision. And it seems to me that when it comes to questions of presidential power, the Supreme Court has moved in an interesting direction in the last few years. I mean, just take the end of the last term. There's the immunity case where the court says we're worried that the executive branch is in the process of cannibalizing itself from one administration to the next, each administration going back and second-guessing the last one in ways that make it impossible for any administration to govern. The court was clearly very worried about the president not having real control over execution. But then just within days of that decision, days before, days after, they issue the Loper-Bright case, where the court says we're not going to defer to presidents or agencies anymore on how to read the laws. There's a significant sort of limitation of presidential policymaking power. Now, immunity seemed to be more a case about personnel. Loper-Bright seemed to be more about policy judgments, but do you think the court is moving in a good direction overall on executive power right now?
Yeah, I think the common denominator there is upholding democracy, if I can use that word. It's sort of misused.
We'll allow it here, yeah.
But I mean, that the people ultimately govern. What do I mean by that? Well, since Watergate, our politics have degenerated. A lot of what we see are reactions against excess, back and forth, and we sort of see the excesses out there. Hopefully it'll come into balance. But since Watergate, we've had government by criminal investigation, one after the other. I'd say go back and watch the news 50, 40 years ago. They didn't talk about legal stuff. They were talking about, what the Chinese are doing, what the Russians are doing, and so forth. You turn on news, especially 5, 6 years ago, it was all lawyers, talking heads. Do you think Section 801 would apply here? It was all nonsense. That's not running a country. That's using the criminal justice process as a political tool. People had enough of it. Immunity was necessary. It's the right thing to do theoretically, but it was necessary to stop that nonsense. Because the criminal process is a way of taking the decisions out of the hands of the people and having single prosecutors like Bob Mueller decide the fate of the country. Okay, that's not good. And the other one was, the administrative state, and the court playing an independent role there is determining what the law is and not just surrendering to what the bureaucrats say. So that, again, is very pro-democracy.
Bill, your point's well taken, but I just got to say, as a lawyer and sometimes talking head, you're kind of hitting me where it hurts right now. You're putting me out of business. You said at one point that we're coming out of a half century of judicial imperialism. So looking back before the Roberts Court, can you say maybe a few more words about that? What caused the courts in the interim between, say, World War II and the global war on terror to suddenly find themselves so confident in their ability to even micromanage issues of war and peace and the fighting of war? What was it about the court itself, the courts, that changed in that half century?
To a carpenter, everything looks like a nail.
Yeah.
Okay? And these are people who, live the judicial process and all its rules and its premises and so forth. And they start viewing the world around them as everything from that standpoint. And it's hard to think of one of the only things I think that they never pushed is the idea that they actually could review and second guess the Fed when it came to interest rates and money supply. They never, let's have a hearing on that. Let's look at what evidentiary base, is there substantial evidence? And we all know that's nonsense. They're going to inject their own views into that. The number of justices or judges that faithfully apply that standard are few and far between. But anyway, that there was virtually no decision in society they didn't feel that they could somehow review to determine whether it was appropriate. And that's simply not true. There are decisions that require weighing and things and does that weigh this value, does that out? And that is for the democratically elected branches to decide, not judges. And I tried to give some examples. And I think the precautionary principle operates in a lot of areas. You can never allow that in our domestic law enforcement system because we can't have collateral damage. But warfare, by its nature, permits collateral damage, and the question is, how much? And that's a judgment call. Because you want to achieve your ultimate objective. Judges are not the men in black we want making those decisions.
Before we move to some issues of the current time, just one more question about your account of history. I was struck by something you said along the way in describing the old wartime cases where the courts weren't micromanaging war. You alluded to cases where natural-born American citizens who were now fighting on the side of the Nazis or wherever they weren't afforded habeas corpus or anything like that. I mean, I take the point, but it is kind of jarring to think that there's a space where the government and American citizens, even in the fighting of war where these citizens have taken up the wrong side, that they'd be outside the power of the courts. That's a pretty strong statement. Really, the American citizens don't have sort of an extra chip on their side?
Well, actually, they do. Because I think after that, I think the Boumediene case was right on this. If the United States uses its war powers against an American citizen, taking the position that they're part of the enemy, there is a risk. The risk is, in theory, not in World War II, obviously, but in theory, the risk is that the United States, the government, is bypassing the criminal justice protections with a pretextual claim that the person is an enemy so that they can use national security powers to oppress one or more American citizens. That's a risk. And so I think everyone has acknowledged that an American citizen has the right to habeas, has the privilege of petitioning for habeas corpus. But what is the inquiry there? The inquiry really is this a pretext, or does the government have some kind of basis for holding this person? You know, another thing going on in the whole area of habeas corpus is judicial imperialism. Mm-hmm. It's meant to test whether there's is this arbitrary that's going on? How deep does that review go? Now, in the case of war, there are two ways to look at dealing with foreign enemies. One is to say they get no process. They're not entitled to due process in the context of fighting a war. The other is to say the process they get is executive process. And if the decision is made by the correct executive decision in a state of war or armed conflict, that's all we look at. We don't say, does the government have enough evidence to think this guy was an enemy? Why do that? Why do you get into that? Especially in war where you can never have complete evidence. You don't have access to all the evidence. Your enemy is concealing their true role. It's a precautionary thing. Where do you put the risk? I'd rather be safe than sorry.
Maybe just a couple more questions from me before we open it up for one or two from the audience. But in our own time, it seems to me there are so many subjects for which we have both domestic regulatory interests but also enormous national security or diplomatic stakes. I'm just jotting some down. And the obvious ones that are in the news now are the president's power over trade or immigration, but even things like CFIUS, foreign investment in the United States, so many aspects of tech regulation now, even we think of as purely domestic regulatory matters. They're very bound up increasingly in national security or diplomatic stakes. Just in very general terms, because each of the specific issues are different, but in very general terms, what mindset should the courts bring to that kind of case? Case about domestic policy, domestic regulation, but the executive branch is asserting a significant national security or diplomatic interest.
So I think the starting point is the key thing is not geography. It doesn't matter where the person is. It's not necessarily nationality. It's what function is the government performing. Is the government going to punish someone for violating a rule? That's criminal. If we decide to use criminal justice to handle a matter, that person's entitled to the rights that people get. We've made that choice. That person gets due process. If you want to prosecute a foreigner, even one who has no attachment to the United States, but you want to prosecute him, we've made the choice, okay? If you are targeting them to eliminate them as a threat and you're using defense, intelligence, and other sanctions and powers, that's defense. And unless the rights of the Americans are implicated, that's the role you're playing. Immigration is an interesting thing. It can have national security consequences, but it's also an administrative process. And Congress can decide what the process is for that. And if we look at someone and say, you don't belong in the country, we're going to deport you, that's not punishment, that's administering the process. And they're entitled to whatever Congress says the process is. On the other hand, if you look at someone and say, you're a threat inside this country, and we're jettisoning you for national security reasons, that's a different analysis. And the president's decision there has to be given decisive weight. For example, on this the enemy aliens thing, or is it alien enemies?
Alien Enemies Act.
Alien enemies. The president would, in my opinion, whether or not Congress passed that law in the 18th century, the president has that power inherently. If we're in war with a country and you want to get rid of push out the nationals of that country for security reasons. I don't think the president needs a statute. I'm not necessarily endorsing everything that was done there, but so that's a hybrid thing. But then the questions of when you take measures domestically to help regiment or prepare or mobilize or toughen society when you're in a conflict, then you have to look at that from the standpoint of whether it infringes rights that the American people have. And in most contexts, those rights are strong, but the government also can have powerful interests in curtailing them a little if it's to protect the country as a whole.
No, in a similar vein, though, you've worked in the private sector, in-house counsel. You have your law firm, the Torridon Group, the Torridon Law. So many of your own clients, I'm sure, they have products, they're industries that could conceivably be regulated by an administration, where the administration might say, we want to regulate even more aggressively. We think there's a national security issue or a diplomatic issue. Today, it's tech. Future administration, maybe there'll be a climate emergency declared, and they'll demand more deference from the courts on climate regulation. From your vantage in private practice, what do you say to administrations to caution them from overstepping their bounds in the name of national security?
Well, I think there is a. Well, first, national security. It's a broad term, but it refers to essentially conflict. Eventually armed conflict is what the core concern is. And there is a danger of future administration, there's always been this, of people using the war metaphor, not just figuratively, but sort of claim we're in a climate war. It's a national emergency of the same as war, and then we have these. That's dangerous. That's a dangerous road to go down.
Yeah.
But and I am concerned about that. But you have to. I sort of think of it. I think the way Locke thought of it, which I think is the truth, which is that when people get together and form a political community, a body politic, they are replacing the state of nature with law. That's what makes law possible. So law is the way we deal with each other within the body politic, and we substitute it for the law of the jungle. But in the international affairs, it is the law. It is the state of nature, essentially. And it's the law of self-preservation that is the true law. It's not the UN Charter or any of that stuff. It's the law of preservation that governs foreign affairs. And it's that simple.
Well, everybody's been so patient. If folks want to ask a question, raise your hand. I'll call on you, and the microphone will find you. Please remember to wait for the microphone to come.
And the Israelis, by the way, God bless them for recognizing that.
And please identify yourself on the microphone. The first question will be there in the back.
Hi, thank you for being here. I'm an incoming 1L this fall, and until about 45 minutes ago, wanted to study national security law. Now, what would you say to young people who are interested in the intersection of law and national security and its implications, and what might a better course of study be?
That's a great question.
That's an excellent question, because it is a fascinating topic, and because after the last 50 years, there are a lot of issues and activities in the field. So just from an intellectual standpoint, it's interesting. I'd like to see more clear-headed lawyers who are actually interested in national security rather than in essentially paralyzing the defense apparatus of the United States. And so, have at it if it's interesting to you. What I don't like about the field is all these lawyers are, the president does something that the travel ban, the original travel ban, this travel ban. That should take about 5 seconds to decide. It's so obviously appropriate at the time, clearly. And years and years of litigation, all these interest groups coming in, all these national security think tanks and all that. It's all nonsense. It's all a waste of time. That's what I object to. We need good people on the other side pushing back against that.
If someday you find him writing in one of these national security law journals, you're not going to hold it against him, are you?
Depends what he says.
Okay. Great. Other questions? The next question is going to be right here, and then the question after that, Max, will be right in the back. Microphone's right behind you, sir.
And Gerald Chandler here. Would you talk about World War II internment, what you think the law should have been and how the law has played out?
Well, the law should have been what it is, which is that, I think people who were established in the United States and lawfully in the United States should have the availability of habeas corpus to test their internment. But I also think, it's easy with hindsight to condemn, what happened, and certainly condemn some of the ways it was done. But at the same time, there was genuine fear at that point, especially in Hawaii, as to, the vulnerability of the United States, the people acting inside. Now, I actually think this is a huge problem these days, becoming one for the United States. What happened with the Israeli attack is instructive. We live in a world where travel, moving things around is much more common than it used to be. And the Israelis were able to pre-position in Iran, apparently, some very potent power. And now we have people in the United States, when you say, gee, the Chinese are buying up all this land real near US bases and so forth. It's like yawning, okay. I think we have to pay attention to what happens in the United States. And we have to be disciplined as to who we admit into the country. And citizenship makes a difference. Who is a citizen makes a difference. And we can't be casual about it.
Next question is here in the back. And then any other questions? Yes,
Good
sir.
afternoon, General Barr. National security lawyer with the FBI and former Army JAG. Concerning the judiciary's usurping the executive's authority in armed conflict, what will be the catalyst to reverse that trend? You mentioned the district courts, probably not, because you can form chop. The Supreme Court, maybe sleep at the switch. What would reverse the trend? Thank you.
The sinking of the US Navy in the Pacific. In other words, either a war or a sharp military engagement where the United States is a 9/11 type thing. But actually, I think this Supreme Court is right thinking. I hope we take advantage of it. I hope the president pays attention to judicial appointments and puts the right people on courts. I think the people he's put on courts good, especially the Supreme Court. That's a good group of people. I think they think the right way generally about this. And in some cases, some of them may go off the tracks. My concern about the Supreme Court is that because it's conservative and institutionally minded, they have this sort of 18th century notion of, no case before its time, our process is such that, it's not the right time to address this issue and so forth and so on. The problem is we've been through 50 years of hell in our legal system. In my opinion, the law has been disfigured in many different ways. And when you get an opportunity to straighten some of this stuff out, this languid, selective approach, will be over before you know it, and we're on to the next period of excess. In other words, you got to make hay while the sun shines, and it's time for them to clarify things. I mean, taking out of the war aspect, right now, every energy in the company in the country is being, sued by all these ankle biters in blue states and blue cities and state courts for their emissions. They no longer feel they control the left, no longer feels it controls the federal government or the courts, the Supreme Court. So they go into the state system and they're posing massive costs on these companies, 30, 40 of these cases. And the Supreme Court will not grant cert in these cases to make the obvious point that you can't be applying local state law to control interstate emissions. It's obvious. And they won't deal with it. God knows why. Maybe, it's just not the time to deal. We want to wait for some other case. I understand, that kind of calculus, but I'd like to see them more interested in societal needs to provide clarity in certain areas. I had a judge that I clerked for on the DC circuit. He would beat the crap out of every clerk and make us go out and fight every office to get opinions issued within 3 months of argument. And he kept on saying, people out there have to run a country, have to run businesses. We can't sit here like we're academicians in an ivory tower issuing, not ready to issue an opinion before it's time. We owe them a decision and clarity so they can move on. And I'd like to see a little bit more attitude in this court rather than avoiding dealing with some knotty issues that have to be dealt with.
We're out of time, but Humor, one last question from me. We've covered so much ground, the past and the present. Looking out to the future, what's an issue, maybe in the ballpark of the things we've discussed today, that you don't think people are focused enough on? Well, what's an issue out there in law and national security that you think we might be spending more time debating, arguing about in the next 5, 10, 20 years?
Well, one issue I'm worried about is the doctrinal neo-isolationism in the Republican Party. I'd be the first to say we should not have knee-jerk reaction and be policemen of the world and spend our blood and treasure at the drop of a hat. But the attitude that nothing, that the knee-jerk attitude that nothing is worth standing up for militarily is always what has brought about vast human tragedy in war. And I see that attitude now gaining strength in the Republican Party. We can't get involved with the Israelis. We can't, do this, can't do that. Because, and then you hear this cant about never-ending wars and stuff like that. Wars don't have to be never-ending. I don't think the current Israeli war is going to be never-ending. And a lot's at stake there. So that's something that I worry about. But I also worry about the culture in the United States, and I worry about our educational system.
Well, just to close, I want to say we here at AEI are so proud and grateful to be a home for Judge Silberman's legacy. This lecture today, as we said, is going to be the first of an annual lecture every year on law and national security in Judge Silberman's name. We're so grateful to everybody who made this project possible. We're also grateful to everybody who could join us today. First and foremost, the Silberman family. Thank you so much for joining us. But everybody, please join me one more time in thanking Attorney General Barr.